important topic. So far, I taught all the topics up to this stage. The last topic I dealt with was that of the settlement of issues. Now this is in continuity. The resource person for today's lecture is a distinguished personality. He was a former judge with rare virtues. He was known as judge of erudition, scholarship, high learning, and intellectual thinking. A casual conversation with his lordship itself was educative. He is an extempore speaker on various subjects. His lordship was sworn in as the additional judge of the High Court of Andhra Pradesh on 17/5/1999 and was appointed as permanent judge on 20th of April 2000. His lordship was appointed as the acting chief justice of the High Court of Andhra Pradesh in November and December 2010. His lordship worked as the president of the Judicial Academy for the period from 14/9/2007 to 7/11/2010. His lordship retired on attaining the age of superannuation on 24th of May 2011. What his lordship insisted is the active participation of all the participants, and he further asked me to convey to all the participant judges that they should indulge in active interaction. So I request all the triary officers to be agile and active in interacting with his lordship. Now I request his lordship to take over the session. Thank you, my lord.
A very good morning to you all.
Good morning, my lord.
Good morning, my lord.
Good morning, my lord.
Good morning, my lord.
My lord.
Good morning, my lord.
Very nice of you to hear the voices from the young officers of our institution, the director of the academy and then other additional director, Mr. Bhupati ji, and all other entire other staff, and you, the all young judicial officers who are just venturing into enter into the active role as a responsible judicial officers. I welcome myself, and you may welcome me, and I may welcome you because I am coming out before you to the Judicial Academy after long gap. So when Thursday, the additional director, Mr. Bhupati ji, requested, I said, all right, I am there, and today on Monday I am with you. I really appreciate the efforts of the academy in arranging these type of lectures on webinar, especially in a COVID affected period where entire activity has come to a totally a standstill, and we are virtually on the real action, and each officer is able to make out something in the process of learning. So I congratulate the officers, all of you, and especially the High Court who has ventured, who has initiated these type of activities, and also all those persons who are responsible. But I may come back to you, those who remember me, on my demission of office as a judge of the High Court. I offered myself for any sort of services of this type of lectures, for any course of trainees on any subject. So that offer still stands, and it is for you people, all of you, whoever is concerned, to take full advantage thereof and extract as much as possible or whatever you can do it. There is a small request from my side to all the young officers, as mentioned by the additional director also. There are two things, especially for this season, this session. One thing is because the short time I was not able to prepare in a comprehensive manner with the slides and other things. Otherwise, I could have come out with a beautiful extracts from here and there. So therefore, I want to I request one of the officers of you, one of your officers, to follow up these with notes and also transcribe whatever is recorded and come and send me the draft of today's session, which is going to be a very vague and comprehensive note. And if once it comes, I will just correct it and send it back to you so that all the officers, not only you but also all other officers and officers, the wing can take advantage thereof. Then another aspect which I personally believe whenever I visited the academy is the active participation by the trainees, by the participants. That is unhesitatingly, there's no question of standing up, even sitting itself, you can pose all the questions, your doubts, and especially now that because you're already officer with experience, you must have had some sort of practical problems or situations which you are you find yourself in a difficult manner. So how to solve it and other things. So we will be able to take up all those questions at the end of my lecture. And I really, at the outset, I congratulate to all of you, each of you, having been appointed as judicial officers and getting a wonderful opportunity to the discharge of your judicial work to the credit of the yourself and also to the institution. And certainly you will add laurels to the in future. And I may recall that you, after appointment, now you already passed a couple of stages. You were already as a school student, had that different experience, and also as a law student, another experience, and also later as a lawyer, and that's totally different experience. So, as a law student and as a lawyer, whatever the experience you had, that is the real practical side of it, which will certainly help you in paving the road in a road of success. So, this will add to your own rather more help rather than coming against you. But now you also must have had opportunity of working with your own senior applicants also. So these observations will also help you while sitting there as a presiding officer and deciding whatever the questions, problems which come before you. Now there are also another aspect, another side of the coin. This is one side of our side, like you can say. The other side of the coin, both as a lawyer and also as you will come across different type of litigants with different type of grievances, with different type of remedies which they are trying to seek, and how they persuade, how they transform, how they rather make use of the remedies which are available under the law, and each one, whether this side or that side, he feels he is right, and he tried to pursue it. Now the court's duty is to find out the truth. So therefore, ultimately, what I am just driving at it is that your discharge of duties is more based upon, more reflecting upon the experiences and observations which you already have and which you will be having hereafter also. So before we commence the entire topic as such about the trial of the civil suit, I would like just to mention about three instances which are very interesting, so that you can also just appreciate the backdrop of those things. One is there is one story in the Bible that is a famous Bible Susanna story. Hope those who have read the Bible and who are acquainted with the Bible possibly they will be knowing. So it's a very interesting situation. It arose there. Susanna, who was one of the beautiful wife of a Joachim, who was a resident of Babylon. He was the richest person and virtually having a honored person, having a lot of control in the society. This is a very actually biblical story which has been referred to in various other later works, including Shakespeare in the Merchant of Venice drama also. So this was they belonged to Roman Catholic Church and other. Then there was one young man, young rather a person with the acquaintance of the law and what you want. Vyavaharika Jnanam, if I can use it that way, that is called Daniel. He's called to be, he's called to be, is said to be an apocryphal by the Protestants. So what happened was the practice in those days was that those who are having in the society, they used to appoint the judges. So the elders, they are called as elders. So some two elders were appointed as judges there, and who used to visit the house of this Joachim also. And Joachim was having a very big house with a garden, beautiful this and all that thing. And his wife, being beautiful wife, was also being more appreciated, having a lot of respect in the society. One day, when she had a bath in the garden, and after the bath, she was returning with her colleague, with her assistants and other things. These two elders who visited that house were passing through the garden and had an opportunity of seeing that lady. And then they with mischievously they fell for her. And this was seen by those who were accompanying that Susanna. So then they were caught red-handed. So they threatened these elders. They threatened that lady, saying that you don't disclose anything, otherwise we are going to hang you, because we are the judges, and we are going to hang you on the making allegation that you have committed adultery with a young man with the same garden. Then the judges had no other place but to try to suppress the whole thing. So they arrested that lady, and ultimately they imposed a death sentence on that. After seeing all this ordeal which was going on at that particular time, how the lady was being rather being made a victim, this young man, you can call it as a young Turk, young Daniel, he interrupted the entire proceedings while it was going on. Then he said, no, 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 this is not the way to put a person to have such a serious punishment of death sentence. I want to cross-examine both of you who have seen that act of adultery in the garden. So then one after the other, they were called, and he said that I will examine only one after the other separately. Then one elder said, yes, I saw that lady committing the adultery under the mastic tree. Then another man, when he came, he said oak tree. So therefore, there is a totally different version. So this has led to the total disbelief of the story as set up by the elders. And ultimately, the presiding officers at that point of time, they put these elders to by punishing them to the death. So this is how the process of why I am referring to this is process of trial. Ultimately, the trial process is nothing but to find the truth. So there is examination, cross-examination, and trying to find the truth in all that. Then there is one more instance when I visited, when I was a portfolio judge in Rajamandri. When I went there for inspection and conferences and other things, I came across a case. How this is a wonderful case. How most of the judicial officers, from top to bottom, from magistrate to the Supreme Court judges also, how we will be misled and we will be trapped and we will be made virtually like a fool themselves. So this case, what happened? A person filed a suit for recovery of the money on the foot of a promissory note, and that promissory note was a forged one. Naturally, that suit was thought to be contested by the defendant after appearance. So normally, what you expect? You expect that certainly he would come out with a defense of total denial, and putting the plaintiff to his heavy burden of proving the forgery and other things and all. No, this defendant, through his a very intelligent lawyer, he was advised and he files written statement. He admits the execution, but he produces a receipt. That's again a forged one. So promissory note forged, a receipt forged, and he pleaded that the trial went on, and ultimately court believed both the documents are true, because what is there now, you examine the execution, you examine a witness to their respective document, there ends the matter, that stands proved. So both documents proved, and the court has believed both the documents and ultimately dismissed the suit on the ground that the amount stood discharged. So therefore, this is how we will not be knowing what exactly is happening behind the scene, and how the things are being manipulated, or how we are being virtually taken carried away. So this is another instance which I thought I should tell you where we commit rather unwittingly walk into certain traps, and virtually tomorrow what will happen to that particular litigation we don't know. Then in another third instance, this is my personal experience as a lawyer. While I was practicing, a poor person, rustic poor person, agriculturist came to me for filing a second appeal. Declaration suit, both courts he lost, and second appeal had to be filed. So when I went through the papers, I found there is nothing, not any question of law, but just a substantial question of law or whatever it is. I told him there is no case at all. Your second appeal will be dismissed at the admission stage itself. But he went on pursuing. He came almost half a dozen times. He went back home, he went back to the village, and again came back, trying to pursue. Then ultimately on the last day, last visit, I just thought there appears to be something which either let us try to probe into it. So I sat with him for a couple of hours and just took him into confidence. How are your children? How the agriculture is going on? How is the weather? How politics? Then he just, after 1 hour, he said, sir, if I can show you some document, if it can be of any help. Then he took out a very old registered document by the other side, which is parting the property in his favor. This document he has neither shown to the advocate, nor was it filed, nor was it taken advantage, nor was it was part of the record. Then I just looked into that is the complete answer. But now standing in the second appeal level, both courts concurrent finding of fact and with the additional evidence where the courts have taken a view. In fact, our own division bench also has taken a view that in second appeal question of additional evidence doesn't arise. So therefore, I just had to think over. But I said, all right, now with this I will take a risk. Let the God help you. Then I filed a second appeal along with an application for additional evidence to receive this document, which is a complete answer. Then the matter came before initially for admission before the Justice Ramchandra Rao. Justice Ramchandra Rao. Then I just told him, sir, there is nothing in the case. Only thing is, if I can make out something, if I am able to convince your lordship about a document which I am filing as additional evidence, then I may have some case. Then he said, all right, I will order a short notice. Then notice was ordered. Other side appeared. Then after appearing, then again both were called, and Mr. Ramchandra asked me, what is the question of law, Mr. Prakash Rao? I said, there is no question of law, no case at all, not a case at all for second appeal, the concurrent finding of fact. But only thing is, now your lordship, ma'am, look at the person who is sitting behind. Absolutely rustic poor. He just brought this registered document, which is complete, show the transfer of title in his favor. This is a complete answer for which other side cannot have any sort of answer or any objection to this. Then he said, what shall we do? I said, this is the problem now. Additional evidence, second appeal, and allowing straight away may not be possible, may not be feasible, or may not be rather right also. So then Justice Ramchandra Rao thought that already he received the evidence, additional evidence, allowed the application, remitted back the matter to the first appellate court for disposal on merits. Then later on the matter went back and the appeal was allowed, and straight away, and against which, of course, again no second appeal came, because the party is still in touch with me. He always comes once in a year and says thanks. So this is another third situation where how we miss. The reason why I am mentioning to these three cases is how we walk into some sort of rather traps, if I can use the word, in spite of our best efforts. In spite of our best efforts, we will not be able to make out another. So therefore, my endeavor and my pointer to you is that you be a virtually as a judicial officer and as sort of like an investigation officer. Whether this side case or that side case, we are not concerned with whose case and all that. But basically, digging for facts is a better exercise than jumping to the conclusion. This is what I personally feel, and this is how I did my I discharged my duties in giving a lot of disposals and relief to the, of course, to the whatever that I felt about justice. Now, before going into these aspects, I have been telling repeatedly the judicial officers whenever I get an opportunity, certain aspects which are the secrets of success of as a judicial officer. There are a couple of points which I'm sure each one of you will make note of it. I mean, in the sense, take care of this situation now. First thing is, don't try to have any sort of hesitation while sitting there. You have a self-confidence. You build up that. See, nothing like having a self-confidence. Don't feel that yes, some senior has come or some other question has cropped up, or I'm not able to understand, or I did not follow this, that, and all that. Have self-confidence at everything clear. Then the other side of the coin is you must have the confidence of the others. You should never make any sort of thing which creates any doubt in the confidence in the bar or confidence in the litigants or confidence in the public and others. So these twin confidence will make you a lot of successful irrespective whether you know the law or you don't know the law. Then secondly, another aspect which will help you in more is having a good English and good grammar, because we are coming across even now. Sorry if I can no doubt I retired and no longer in the office, but still we are coming across many orders, many different levels, not only at lowest level but also different level with a lot of bad English and bad grammar. So nothing like reading a literature and like nothing like trying to improve the grammar and help yourself. This apart, I personally feel that if you want to be a successful judicial officer, you have to have a Vyavaharika knowledge. Vyavaharika knowledge means the worldly knowledge. Worldly knowledge, if otherwise, if you just sit in the four corners, four walls, and try to discharge without knowing what exactly happens societally, then you will not be able to know anything. You must know the history. You must know the other literature. And I suggest you that you please try to read your own the history of our own country, history of the world, and also certain relevant certain books like Gibbon's Decline and Fall of Roman Empire and Discovery of India and Glimpses of World History by the Jawaharlal Nehru. Maybe some of the officers must have already heard me and maybe I am repeating. You must also there is a one list has been prepared. I had given to the academy long back. A list has been prepared by the Judicial Academy of the Bangalore, where shortlisting the books which each officer should have at least one reading. So please, if the Judicial Academy requires, I can supply the list again later, which you can make available. Then that apart, also you must improve your general reading. Like as I told you, economics, psychology, and other things. These will help you ultimately in not only developing the language, but especially the reasoning portion, and also in understanding the core area or that circle within the circle of each problem. So therefore, this is a very much necessary, without which I am sure that we will not be able to discharge the duty except becoming a rubber stamp or something like that. Then other aspects is the basics of the law, the philosophy of the law, basic principles of the law, the Salmon jurisprudence, Halsbury's laws, and all the Privy Council decisions and all the most Indian appeal decisions. If you get an opportunity, please don't miss that opportunity of at least once in a while by reading and other things. Now coming back to this topic, initially let us just make a beginning that what sort of inquiries we are having now, what system we are having, which requires a sort of trial in every civil suit or on a criminal side or civil side, whatever. Then I hope you are all aware that there are two types of systems which are involved. One, that is inquisitorial and adversarial. So inquisitorial is a system where virtually judge does every aspect. He becomes an investigation officer, he conducts everything and all other aspects. This system is prevalent in some European countries and also especially retained in most of the criminal side. But now we are not having any that type of system. We are having adversarial where the parties come before that. They represent through the lawyer, and this is more prevailing in the common law countries, both in civil side and criminal side. The parties and advocates, they are responsible for preparing the case, presenting the case, and ultimately conducting the case and everything. The judge has absolutely no role at all to make any sort of investigation. So therefore, this is what the system which we are following. I hope you must have already had this type of account earlier. And now coming to your duty as a judge. See, there have been different approaches in all in the history. In the ancient Hindu Dharma Shastra, the of concept originated. What exactly is the object of the trial? The purpose of any trial is the desire to find out the truth. What exactly is the truth? As I was mentioning to you, and let us not walk into a sort of something and put trying to give our own stamp there on that. Then Yajnavalkya, one of the renowned scholar, he said, discarding what is fraudulent. This is what happened. Discarding what is fraudulent. The king should give decisions in accordance with true facts. So what are those true facts? This is exactly the proof which is required. Then Shastras also, as per Hindu Shastras, they command the parties coming into the court must be persuaded to admit the truth. So you must endeavor should be see that how best the parties can come around and ultimately come back to the basic truth and what exactly on which the whole dispute rests on it. Then Manu says, the king presiding over the tribunal shall ascertain the truth and determine the correctness of testimonies of the witness, the description, time, and place of transaction or incident giving rise to the case as well as the usages of the country and pronounce the true judgment. Then Vashishta also says there are different kinds of evidences he refers to, like Likhitam, that is documentary, Sakshi, the oral, Bhukti, again permanent Trividham. So these are all Lekhya, Sakshi, Bhukti. Lekhya means that which is a document. Sakshi means those through the witnesses. And Bhukti means the possession. Possession. As you are aware, the possession is 9 points in law. So that also is a very important piece of evidence. So the judges should extract the deceit like a physician taking out from the body Amron thought with the help of surgical instruments. So that should be the approach, like almost a surgery. A surgeon does the entire act of that. So this the now the what exactly is the trial? The judicial examination before a court according to law of facts and law put an issue in a cause. Now the entire endeavor should be truth should be the guiding star in the entire judicial process. Truth is the foundation of justice. This is what now one of these observations are by Justice Krishna Iyer reported in. I hope you make a note of it, which is a very interesting reading. AR 1977 Supreme Court. AR 1977 Supreme Court 1011. This is Jasraj Inder Singh case versus Hemraj Mukund. He says, truth like song is whole and half truth can be noise. Justice is truth, is beauty, and strategy of healing injustice is discovery of whole truth. And justice need not be defined in order to be understood in their true sense. They bear with them the shining beauty and heavenly light. I firmly believe in the triumph of truth and justice. Now I just recall something when I was practicing. I just I used to have good relations with most seniors. There was one of the finest senior, both on civil side and criminal side, one Mr. Jalil Ahmed. He used to say, Mr. Prakash Rao साहब, अपना काम ऐसा होना चाहिए जिससे चंदन की खुशबू आना चाहिए. So each action, each act, each order, each reasoning which you give ultimately, which follows, is a reflection. You should reflect that particular like a smell, like chandan smell, and it should be one should feel that happy to read. In fact, I can share with you that out of my experience as a lawyer and also as a judge, I found most of the judgments given at the lowest rung, that is by the munsifs and magistrates, are more pleasurable to read than as you go up. Because as you go up, it starts gets filtering, and the moment when it lands in the ultimate court, it becomes almost like a SMS like that. So therefore, one has to your endeavor should be to see that really all such reflection is being availed. Then approach of a trial judge should be judicious one. Repeated comments without making a note is not judicious. Many times what happens is the judges, they just go on reacting. They go on, yes, come on, proceed, come on, what, all right, don't do like that. I heard you, yes, I followed you. So this sort of hurrying, because till yesterday we were also lawyers, and we also know how to feel when judge makes a comment. Yes, bas karo, yes, proceed further, or yes, I understood, you need not go to next point. This is not, there's another method of also handling such situations also. So you should be always be you should be not be you should be uninfluenced by any sort of dramatical actions either by the lawyer or by the party. Suppose the parties they make a lot of dramas by getting tears in the eyes, and also by making any faces to the towards the other side and other things and all those. This is what will be reiterated by the Supreme Court in these two decisions, which are very important. You can make note of it. That is, one is 1976 Supreme Court 1782 and 2012 Supreme Court 2955. Now, coming to what certain maxims which I thought I should share with you, which are relevant for the purpose of the trial aspect is concerned. One is the following the basic principles of natural justice, RD Antrim Pattern. Hearing before action or order having which has got civil consequences. So this principle has to be blindly followed by every one of us in every case against every person, every lawyer or every party. They should not go out of your premises with the grievance that he was not heard or not he was not considered, something like that. So these principles are very nicely considered in very earliest judgment especially in civil cases. In ILR 35 Calcutta, ILR 35 Calcutta 767, ILR 1 Calcutta 333, and AR 1929 Madras 393. Then another principle is actio personalis moritur cum persona, right of action extinguished by death, like personal relief, like especially like personal relief like that. So whenever a person dies, what happens to the remedy which he has availed, or what happens to his rights is another question, which has not, but not in regard to the property and other aspect. This has been considered in AR 1958 Supreme Court 1042. Then another principle is maxim is actus curiae de nemine facit injurium. An act of court shall prejudice no man. So this is what actually you should be very, very careful while in discharging the functions and attending to regular work and other things. Not try to make sort of any person to his disadvantage. But so therefore that is what exactly happens normally whenever we are in a hurry or parties in a hurry, lawyer is in a hurry, and many things go unnoticed, and ultimately it is the parties who suffer. So actus, another one is actus curiae neminem gravabit. Court's own mistake should not be allowed to survive to cause injustice and not on merits and conclusions. So therefore, any mistake by the court, see this principle you can find get reflected in section 152 of the CPC. So justice and good conscience, good sense. So these are all the grounds on which certainly you can always try to help, and you can. The Supreme Court also had in many situations the courts, even though final orders have been passed, but they have recalled in a given situation, of course, no doubt. Then void ab initio, non-honest. So this is a totally without jurisdiction, as if it is not existing. Now, like you see, Section 10 of the Rent Control Act says no decree shall pass except as provided under the Rent Control Act. So, but a suit can be filed. But this is virtually what is the use of such a decree? Honest. Then suppose some ex parte proceedings have occurred and the subsequent after the regular trial, then that is set aside later on. Then what happens to that entire evidence which is recorded? The line of thinking is that everything goes. You have to begin from beginning. Then another principle is falsus in falsus in omnibus. False in one thing, false in all. This is a very bitter principle. Of course, the Supreme Court has held in 1974 Supreme Court, so 1168, that this may not have an application to the Indian circumstances, and certainly the um, artists can so go on changing their colors, but ultimately it is for us to separate the water from the milk, just like Swan does and other things. Now, these trials, now you look at where exactly the trials occur. Normally, the trials are contemplated, or the trials are found necessary, or trials are also virtually a mandatory exercise to be done by the presiding officer wherever they are conferred with the original jurisdiction. So this is a necessary incident to any case or dispute on original side. And in appeals, this type of trials, or sometimes in exceptional cases, in appeals and at higher level also. In fact, I myself conducted one first appeal, a regular examining a particular witness instead of sending it back and other things. That's the exceptional one. But wherever original jurisdiction is there, trial is necessary. Now you look at High Court also has got original jurisdiction in respect of certain like election petitions. In an election petition, the trial goes on in the High Court only. Then Supreme Court also under Article 71, the election petitions of the President of India and other things, they go between they are conducted in the Supreme Court. As if it's a regular suit like before a municipal court. Then similarly, a dispute between a government of India and states, or a state and state, or two states and three states and government of India. Under Article 131, this suit also lies only in the Supreme Court. So there again, many times they try to avoid it, but virtually a regular trial or inquiry is contemplated. So the basic principle which follows is wherever the original jurisdiction is confirmed, it is a necessary corollary that one has to have rather a regular trial. And now coming back to where exactly you find these trial provisions, you trace in the code, that is civil procedure code. What exactly the civil procedure code? What the type of the law? There are two types of law in the one is procedural law and substantive law. Civil procedure, I maybe I am repeating many aspects which you must have already had, but still, my approach is only to see that how best we can put these principles in practice and come to the aid of the parties who are standing before you. So these procedural laws, not only according to me, but even commencing from the 1954 Madras and again the Supreme Court and 60 Supreme Court, and also later on the Supreme Court, I will use the references also the latest one, where it has been held. The procedural laws are designed to facilitate justice, and they should not be treated as an enactment providing for punishment and penalties. Law of justice should be so construed as to render justice where reasonably possible. For these principles you get reiterated recently, AR 1990 Supreme Court 1828, that is Chinnammal case, then AR 1998 Supreme Court 1624, then 2003 Supreme Court cases 242. Now, stopping here for a minute, because I am basically, as a judge, I was very liberal, especially procedural aspects concerned. There have been many occasions where I gave an opportunity, even at the fag end of the stage of the appeal. Even in the first appeal, in fact, I allowed many such things which could have been done in the trial court itself. I did not hesitate to give an opportunity. The basic reason is you just try to appreciate. Suppose you reject an application or you don't provide an opportunity. Suppose you don't receive a document, or suppose you don't examine a witness, or suppose you deny, suppose set ex parte or something like that, or some amendment is being sought to be refused. What happens? what happens is that it is you, it is not the parties. Look at from our angle now, because we are not trying to take any sides of the problem in a dispute. But now it is we, it is you as a presiding officer, the court, which will be deprived of having a posted with the all the aspects from both sides. Even anything going amiss is certainly going to lead to a lot of injustice or maybe totally erroneous conclusions. Suppose what happens, suppose I produce 101 documents, complete rather sanas, farmans and everything to show the Charminar is in adjacent to Secunderabad railway station. Are you going to decree it? So these are all things which will there. So therefore, now you have to have rather provide an opportunity. Whenever a person comes, yes, I want to do this, yes, give him. I want an amendment, yes, give him. I want to examine, yes, give him. I want to file this document, give him. I want this order set aside so that I can have some opportunity, give him. Doesn't matter because only thing we are now, especially of late for last few couple of centuries, 10 to 20 years, because of the pendency and pressure of work, we are being denying, and also maybe I have not said that litigants and the bar members are also trying, certainly taking advantage thereof, but certainly that is not an answer to provide an opportunity and interpret the procedural. It is not a substantive law where you are to have a sort of say, one final say. So this is my approach. Now, how exactly the problem comes to the stage of the trial? How exactly the whole thing arrives at it? Firstly, basically, between two parties, a dispute starts. Some sort of claim, denial, or some assertion, denial, and all that. Then sometimes followed by exchange of notices or maybe exchange of correspondence. Then ultimately, filing of a suit. Whatever the suit which is to be which is being advised, which is more so thought to be more reasonable, more apt and other things. Then there follows in after filing of the suit summons. Then summons after the summons pleadings, written statement, then rejoinder, the documents, claiming of issues. Then after claiming of the issues, now the plaintiff's evidence commences. And after the plaintiff's evidence, defense evidence. Then after the defense evidence, the plaintiff's rebuttal, of course, subject to his reserving that right and other things. Then comes ultimately the arguments. Arguments later to argument is our judgment. Then after the judgment, the appeal. Then appeal after the appeal, the execution. These are all different type of stages in a suit now. Now, this trial, what do you mean by trial? Because the academy has asked me to speak on the trial in the civil suit. So I was just wondering, when I shortlisted like this, what happens in the regular course of events in a list before a court of law? So this starts with the dispute between the parties at their home and ultimately reaches to the stage of the logical and the stage of execution. So where do you say the trial begins? Where can you say the trial ends? Whether it starts with the exchange of notices, filing of the suit, or really after framing of the issues, or does the judge arguments are include part of the trial, or judgment is a part of the trial? These are all queries where certainly gets a sort of the everyone tries to get it. Now, if we try to narrow it down, because the trial is not defined in the code of civil procedure. Now, if we, with our experience behind, as a lawyer or as a judge and other thing, what we see is the trial actually leads to say that yes, after framing of the issues, basically initially there is a practice in many of the courts that both the sides will be given opportunity to make the opening statements. Then evidence by the plaintiff, the chief examination, cross examination, evidence by defendant, again chief cross, and again rebuttal, and again chief cross and argument. So this is the virtually it can narrow down to the very term. Now, even considering, I was just going through the provisions of this code of civil procedure. Now, the other where exactly I should whether I'll to what extent to what rather extent only to what extent I will be right in saying when the academy has asked me to speak on the trial. What are the provisions which I should refer to? What are the provisions which I can conveniently avoid? Now look at from this order 10, examination of parties. Order 11, discovery inspections. Order 12, admissions. Order 13, documents, productions and impounding and other things. Then order 14, issues. Whether trial begins before framing of the issue, the moment it is rejoinder or letter statement is fine. Then order 15, disposal in the first hearing itself. Then 16, order 16, summoning of the witnesses. Then followed order 16A, attendance of witnesses. Then order 17, adjournments. Then order 18, hearing, examination of witnesses. Then order 19, as amended, has now been through CPC by through the affidavits, the examination recording through the affidavits. Then order 20, judgment and other things like that. So these are the orders. If I can say, where shall I begin? Where shall I begin in section 9 or say section 9 of the suit itself, or order 10, or order 14, or order 18, and other like that. So therefore, I was just wondering what exactly you mean by the trial, because trial having not been defined anywhere. Because but the expression trial and the expression trial has been used at number of places in the CPC. Section 9 itself begins saying the court shall have jurisdiction to try all suits of civil nature. Try. So what exactly you mean by try? Nothing is there. Section 10, you should not proceed with the trial of the suit if there another matter is there. Then section 11, the judicator, no court shall try. Like this is something like that. The as I was mentioning to you, section 10 of the Rent Control Act. Then section 15, the institution. The institution. That means here now look at reading for the section 15, because I'm just trying to read in between lines also. If you look at, if you just narrow down and raise pointer to section 15, it says your institution of a suit should be in a court which is competent to try. That means your trial starts through the institution itself, because unless you institute, question of trial doesn't come. Then section 24, the power to transfer from one court to the other, and also 25, transfer by Supreme Court. These are also the expressions, the trial and the try or dispose of or retry, because Supreme Court also, while ordering transfer, they can, in a given situation, they can order for retrial. That's what the expression is there. Then section 90, a special case trial, is the word expression is try. Then section 141. Now I just told you about section 15. Now look at the section 141, miscellaneous proceedings. All miscellaneous proceedings follow the procedure followed in suit exclude order 9 article 227 Now what does it mean? That the entire procedure as contemplated from the beginning to the end under the code of civil procedure will also apply to all the miscellaneous proceedings. Suppose I file a mischievous, some hopeless IA, so I can go on invoking each and every provision under the code of civil procedure. So the person, and you possibly you must have also had an experience. We had a good experience, because I had an opportunity of working in the city civil courts in my initial 4 years from 72 to 76. I was rubbing with all those different typical type of lawyers, which holding only that CP Ananta Babu's code of civil procedure or Ugulapati Chaudhary's code of civil procedure in their hand, and making use of each provision for every occasion, for everything, and suit and the matter doesn't get disposed of at all. It's only the moment, it's only the amount of grip which you have over the provisions which enables you to take full advantage thereof. So therefore, I will come to you another aspect which is a secret of success as a judicial officer, as per the legal aside is concerned. But having a full control over the code of provisions of the code of civil procedure by you, the judicial officer, by any advocate, is a touchstone. Not only is a trump card where you can certainly see that you can get a decree to hold that Charminar is in Secunderabad only. I'm telling you. Then section 153B, place of trial, is also the, it says place of trial. Then order 1 rule 3A, wherever suppose there's some sort of clash of different among the defendants, then separate trial has to be done. So order 2.6, separate trial wherever there is a joinder of cause of action. Then order 6 rule 17, then order 7 proviso, which is a pass. And any amendment after the trial commenced. What do you mean by after the trial commenced? Can I not file application at later argument stage? Can I not do it later stage, or can I do it immediately? In fact, there are also situations the moment the plaintiff is filed, also followed by an application for amendment also have come up. We have come across such situation. What do you mean by after commencement of trial? But one thing is stopping here for a minute. Now the CPC has undergone, I'm just trying to help you. CPC has undergone various amendments on the recommendations of Law Commission, and ultimately, I mean, adding so many provisions with a view to control the delay, to avoid the delay, and to see that all these delay tactics and other things will be avoided. But in Salem Bar case, and also other the different high courts, including our own high court, has considered each of such provision. Each, suppose you can't file the documents later stage, you can't file amendment later, like after commencement of the trial, you can't do this, you can't do that. All these things have been watered down to say that these are all not mandatory but only direct. Because the reason you may ask, why the courts have, why it has led to the courts to hold so. Basically, you may possibly thought to it that because it's a procedural law. As I was explaining to you that you have to be liberal. Give an opportunity. Suppose I walk into your court. I say that I am the owner of Golconda Khila and I file a suit. I produce all the documents and other things. So therefore, what should happen to that? So what sort of inquiry a trial has to be here? What opportunity has to be given and other things? Where the truth has to be found or not? So therefore, these are all held to be mandate, no, not mandatory, but direct. So this trial, I just for you can make note of certain decisions which I came across. The definition, the defining about explaining about and the expression, considering the expression trial. One is AR 1980 Bombay 188. It says the trial meaning. The AR 1980 Bombay 188. This is Sujana Bai's case. Trial meaning narrow and wider sense, like only final hearing, examining witnesses or arguments, or connote entire from the date of institution. Then there is earliest judgment is ILR 27 Madras 493. Then AR 1929 Madras 201, which says trial means it also includes judgment. Now, another aspect is another aspect which I thought I should tell you is about this Order 6 Rule 17. As I mentioned to you, the mention commenced after the commencement of the trial and other things. Order 7 Rule 10, return of the plaint, says it also at any stage. But what about Order 7 Rule 11, rejection of a plaint on that certain grounds, no jurisdiction, limitation, whatever the grounds are there. This provision doesn't say anything like that. So does it mean that you can file at any stage? Or you can, because there have been different approaches. Most of the judges, some of the judges, including subordinate officers, also have been discussing. Such application should be filed only immediately after at the inception itself, initial stages only, not at the later stage after trial and everything is over. But now this Order 7 Rule 11 provision is being fully taken advantage of by most of the litigants also. Whenever they find some sort of adverse situation, adverse things are happening or some practical difficulties are being faced by them. So therefore, this trial has got, I mean, if you read like this, I'll come back to this another very interesting provisions of law which will explain to you about the trial and other aspects. But this trial, the expression which I use is trial, proceedings, inquiry, hearing. So the trial expression, as you and I, we understand, it includes hearing, inquiry, and everything. Possibly the inquiry also includes the hearing. Possibly the proceedings also include the trial. So these are all expressions which are only interchangeable, and ultimately the bold steering principle which evolves, which can be culled out from whatever the principles laid down by various judgments and other things, that you have to have a sort of an inquiry, a trial, a proceeding, a hearing, where following the principles of natural justice. Natural justice, notice, hearing, pleadings, documents, consideration of document, consider submissions, I accept or reject, give the reasons, and pass the orders, and communicate, and something like so. Therefore, this is all there. Now, this including on order 33, indigent person inquiry. There, the expression used is inquiry. And order rule 7 says you must also examine and hear. So therefore, these are all very ultimately leading to those basic principles under the principles of natural justice, not otherwise. So there now, as I was mentioning to you, where do you get this trial? I had a little search. Possibly you must be aware that not. I don't say that you are not aware about. There is one interesting act which we are mostly concerned, especially in the trial court, because this is the Bankers Book Evidence Act 1891. Act 18 of 1891. There you can make note of section 2.4. Section 2.4 defines legal proceedings. Legal proceedings means any proceeding or inquiry in which evidence is or may be given. Any proceedings or inquiry in which evidence is or may be given, or investigation or any investigation so and so. Then 2.5, the expression court means the person or person before whom legal proceeding is held or taken. So therefore, it is that legal proceeding as mentioned in section 2.4 which is being held, or where it is held, it is known as the court. Then section 2.7, this is one. This is a complete. I didn't come across the expression trial being statutorily being defined anywhere in any of the provisions, in any of the statutes at all. So trial means any hearing before the court at which evidence is taken. So therefore, the CPC and the Evidence Act steps in. The trial means any hearing before the court at which the evidence is taken. So therefore, we are not short of any sort of understanding in the expression trial is as wide as anything. So if that will be so, if we restrict this one where evidence is being taken, again the question will arise: Are we to begin the trial only after the issues, or are we to begin the earlier from the date of filing of the suit? So therefore, these are all questions which crop up for consideration. Now coming to the other relevant piece of the law which is relevant is the Evidence Act, which is necessary to be considered because it is the Evidence Act which has got a greater role to play in the process of trial. So therefore, this as I was mentioning to you, apart from you having the full control over the provisions of the CPC, it is the control of you or even any advocate, my suggestion, any advocate, over the complete all the provisions of the Evidence Act, which will be help you a lot. In fact, he can make and I may do and undo anything. He can make the day as night and night as a day. So therefore, those who are having a full control or understanding the provisions of the Evidence Act, they can, as I was mentioning to you, I can also get a degree that Prakash Rao is the owner of the Charminar. So therefore, this section 1 of the Evidence Act, which says it applies to all judicial proceedings in or before any court. So here, section 1 says judicial proceeding. Section 2(7), Banker Book Evidence Act, trial means court where evidence is taken. The legal proceedings mean again an inquiry in which evidence is taken. So the judicial proceeding and legal proceeding, these are all again ultimately interchangeable. And therefore, and section 3 contemplates that every judge is authorized to take the evidence. Now, section 101, this is what elementary rule, which is a burden, placing the burden of contemplating the burden of proof. And section 104(2) says burden of proof lies initially on the plaintiff and once it discharges shift. So this burden of proof, as the case goes on, it all goes on shifting. I did not say about all these things, but it's each case will have its own repercussions and other things. Now, section 5. Section 5 of the Evidence Act contemplates what are the relevant facts, the relevancy. Then 167 says about the admissions and rejection of evidence and no trial at all. So therefore, if you read these provisions of the Evidence Act, the law of evidence, and different chapters thereunder, the type which include the oral and documentary and other things. So what it says is only that which is legally permissible is allowed to be taken. That is called legal evidence. In the absence of any legal evidence available, nothing can go in. And there are different provisions are there like admission, documentary evidence, burden of proof, witness, examination. The Evidence Act also contemplates all these things. So they ultimately, the reason why I am mentioning about the Evidence Act is, of course, the trial is only considered to be part of the CPC and other things. Because you are now more burdened with many of the obligations. If I can use the expression as obligation, to see that whether the legal evidence is coming forth or not, or anything illegal aspects is coming into on recall. So there are two aspects with which you have to rather keep all your eyes and ears open about is admissibility and relevance. This is a core, whether that particular evidence or that particular document is admissible, or whether that thing is relevant or not. So these are all aspects which are I mean very succinctly discussed in the Supreme Court case in 1998 Supreme Court 1850. So it is here your role steps in, whether one witness is being, whether the right witness is being examined or not, whether particular questions have been relevant or not, whether that particular aspect is pleaded or happens is most of the judicial officers, they just allow both sides to have their own say, while especially at the time of examination of the witnesses, they just play virtually docile role, and they feel that any interference at this stage may not be liked by the advocates or parties and as such. So therefore, you have to have rather more careful enough to see that now with the introduction of Order 18 Rules 4 and 5, it contemplates witness examination can be dispensed with taking the affidavit. Now, this provision has made a lot of sea change in the entire process of the very trial, because it has become very easier for the parties to go on saying all Charta Bharatam in the affidavits, much more than what is pleaded in the pleadings and other things. And ultimately, the party when asked one question, whether have you read this affidavit? No, I have not read, or I am not aware. Then the cross examination is being done before the commissioner. So therefore, we judges, the trial court judges are virtually being deprived of the opportunity of listening to the witness and the evidence as recorded, or observing the demeanor or whatever you call. In fact, the basic principle here, stopping here for a minute, it says section 1 of the Evidence Act itself says it applies to everywhere but not to the affidavits. So therefore, you as a judge, you as a court has to go only by the law. Rule of the law, legal evidence means that which is permissible under the Evidence Act, but not otherwise at all. So if the Evidence Act doesn't permit the affidavit, then where do you step in? How do you allow it? How do you allow it to be taken at all? And there are certain decisions. In fact, to make just note of this thing, affidavit is not an evidence at all. These are all decisions which repeatedly are held. I can just give a list of these cases. You can make note of it. 1988 Supreme Court 1381. Then 2006 6 Supreme Court cases 94. Then 2002 Supreme Court 1147. One two six zero 1977 Supreme Court 1512. 1972 Supreme Court 330. 1981 Supreme Court 1298. 1992 Supreme Court 700. So ultimately, my point, the point which I am just trying to press upon at this particular moment is, if affidavit is not an evidence, how can you allow it to be taken? Now, of course, the Supreme Court in the Salem Bar case, that is Salem Bar case, I hope you are aware, 2005 Supreme Court 3353, that examination chief can also be recorded in court. So this is what is being said. So that means, if you just look from in between the lines, it is not that in every case the affidavit should be blindly followed up. This is what I am trying to drive at it from a more practical angle. Because suppose take for instance a comprehensive suit of declaration, title and other things, where so many questions are involved and other things are there. They are seriously being contested. Evidence, documentary evidence, this evidence, that evidence, this pleading and that pleading, so many substantial pleas are being raised and other things. Can you just blindly say that yes, affidavit and one affidavit on this side, one affidavit that side is enough to decide about matter? Certainly not, may not be. So therefore, you may have to draw a distinction. Of course, you have to take into confidence the concerned parties and the concerned advocates, whoever is appearing from both sides, and then draw a distinction between the suits where you can go ahead with the affidavits and suits where you can't go. I can understand, suppose some money suits. Some money suits, some monetary aspects, the simplicity is involved. You can just possibly opt first. But wherever there is a contested, heavily seriously contested, even there are many cases. So it looks like a simplicity suit for injunction, but questions are at large, very, very comprehensive, very seriously being contested, and substantial stakes are involved, and substantial vested rights are being discussed there, being claimed, counter-claimed, and also being denied. So therefore, in such cases, necessarily my suggestion would be that better to opt for a regular court hearing and examine the witnesses rather than opting for the affidavit and other things. Now, this another thing which is happening is about the video recording of the evidence through the video call. So again, same, it has got its own merits and demerits. No doubt it looks easier, just as we are now conducting the classes through a webinar and other things and all. It's very easy, it becomes easier for us. But still, even this type of conducting class also has got its own limitation. You are not able to see me, nor I am able to see you, nor I don't know whether you are really following me or not. You don't know whether really it's something properly conveyed or not. Or maybe sometime in between or in the midst you get a sort of doubt, or suddenly you want to just stop and ask something as that cannot be done in the manner in the manner which normally we are habituated. Apart from this, video recording has got again its own same thing. You don't know whether there's anybody sitting there with thinker there or not, and other things, so many other aspects are concerned. But as far as our this the reason why I mentioned initially about our system which we are following, rather not inquisitorial but adversarial, so necessarily adversarial system, where I'm just trying to pose a question to you. Where do we stand? Just simply following the affidavits and videos and other. To some extent, to some aspects, you can restrict, but not to all the aspects and to all the extent. So this is my submission. Now, the part of the trial, now the as I was mentioning through the witness examination, and many times we don't know whether witnesses are they have been directly brought to the court. We don't know, because many times I was told as a junior, my senior, better in any third party, don't examine him unless you get the summons. Many times the summons are being sought to dismissed. And we are also not insisting the summons should be taken. At least it gives an impression that he is a third party uninterested in other. So these are all aspects which has to be rather considered at each case, at each stage, and at each witness, and at each aspect whenever. Now, even the process of the ADR methods as Section 8, as contemplated in Section 89. Now, this is they're all things which are now staring at regular course. Now, those who are sitting on the other side of the ADR presiding officers or concerned officers, they are doing no doubt good work, but still this whether there are these methods also, both the lawyers and judges also have their own difficulties. So therefore, as long as we try to do our duty in a more pragmatic and practical side by trying to give the disposal in a manner which is expected by the party when they come to approach to us, and with a lot of confidence in us. No, we trying to relegate. We're trying to we're trying to rather take the response out of our shoulders and let it slowly by allowing the affidavits, allowing the videos, and allowing the mediation. What is the signal we are sending? Is this just docket filing staring at us? No, you should not get afraid. There's a method of doing it also. There's a method one should learn how best to do it. There has to be where there's a will, there's always a way. There are some judges. In fact, when I was in Guntur, I found about two or three courts. I found one judge exclusively reserved the pre-lunch session for arguments and post-lunch for trial. And whereas another officer trial pre-lunch session for trial and post-lunch session for something like. So therefore, this is all way of arrangements we can do it. And ultimately, I'm telling you, if we just open the bundle, open the case, open the matter, allow the parties so that to begin with the case, there will not be much thing at all. Because gone are those days, I'm telling you, warning you also. Gone are those days where almost 80 to 90% used to be very serious matters involving mortgages, partitions, these adoptions, gift deeds, and so many personal laws matters and other things. Serious questions are involved, estates are involved, and other things. Nowadays, mostly are every dispute is being converted to an injunction. And injunctions, another thing which I want to make suggestion to at this particular juncture is, when I visited last time to Warangal, I was telling the offices also, almost 70 to 80% matters are of injunctions. though in the given situation, the relief could have been for a comprehensive relief for declaration or something else. But still, what they do is they just try to take a chance, file an injunction suit, all right, injunction given, obtained, keep it pending. Ultimately, the courts will say, the highest court will say, no, this is not the relief. You seek that relief. And then again, begin from beginning. So therefore, this is where these type of situations are almost coming in every alternate case. This is what my feedback is there. So therefore, my suggestion to you is, even in a injunction suit, just open the bundle and see whether any serious question of title is involved. The moment serious question of title is involved, raise an objection. Because you can raise an objection at any stage. If Section 11 of the Code Act allows you to do it, and ask them to file a appropriate application for amending the prayer or paying the court fee or something. Doesn't matter. Don't worry about the suit going out of the court also. But this has to be this exercise has to be done. There are two exercises which I feel necessary to suggest. One is, in every case, just make an attempt under Section 89. And in every case, just make an attempt under Section 11 of the Code. I'm sure these two things will lead to rather to give a second thought to the litigant public to have a sort of either easier settlement or easier disposal or just solving the problem. So these are all aspects which I thought I should share with you, because I am not so strictly speaking to you on the each and every provision concerning all those orders, the trial and other aspects. But now, basically, you as an officer, especially in the process of trial, forget about till after the issues are concerned, until after the issues are claimed. But again, before the issues are concerned, another aspect, before the trial begins, please again hear them again. Hear both sides, what is your case. Then find, just look into the issues, whether issues, because normally what's happening, the framing of the issues, basically is a duty of the court, not that of the counsel or the parties at all. But now we have opted for our so many couple of centuries that we are asking the parties, counsel to frame draft issues, and that is being adopted. So therefore, we come across situations where issues are not being properly. So just make an attempt to see the proper issues are claimed or not. Then give a proper equal opportunity to both sides. Then once the trial begins or likely to begin, fix a schedule. Trial timings, all the forenoon or afternoon or day to day, or at least every once alternate day. The moment it begins, try to see that it is given comes to an end as early as possible. Then just check up whether you are following all the procedures as followed, as prescribed under the, especially under the Code of Civil Procedure, and more so under the Evidence Act and other things. Then recording of the evidence is concerned, witness examination is concerned. This also not being not very. I mean, mostly the advocates are dominating and they are trying to see that their version is being recorded. But still, the better to see that ultimately we are catering to the need of that particular law, that the justice of that particular last man, that common man, that poor man who has got still kept your mouth and eyes open and awaiting for some sort of justice from our hands, so that he will get it. Then maintain the court time. Whenever no delays. In fact, when I visited a particular district, I will not name it. I finish off by after lunch, and 3:30 or 4, 3 o'clock also I made a surprise visit. The entire court premises was empty. The district court premises. It has appeared in the newspaper also. So therefore, firstly, availability of the officer during the court time and maintaining the court timing is very necessary, especially in the trial, because parties come, when the witnesses come, the lawyers come. Once they know that this is timing is maintained, they will also try to maintain themselves, and certainly, secondly, and maintenance of manners, maintenance of the dress, and with always try to have a broader smile, because your smile will send a lot of positive signals to you. That worried man, that worried sort of creates confidence in you. Then, as I was mentioning to you, liberal in your approach, in fact, is liberal in the sense you must. No party should feel that he has not been given an opportunity, or this has been denied, or that has been denied, something like that. No. And let us not try to control the entire court premises with all good other rapport and other things. And there is no question of distinction between the senior and lawyer, and just equal treatment, and because even the junior also feels rather more confident the moment he is being treated as if he is himself. So therefore, once the before commencement, as I was mentioning to you, as I already told you. So therefore, the concentrate and especially when the trial is going on, please concentrate on what exactly is happening, what is being said, what question is being put, what answer is being put, and what is being recorded and everything, because this will ultimately help you on your way. So, and another thing, normally, in the course of once the trial begins, the real problem begins in fact. Because it is at that particular stage, so many things crop up. So many applications, one after the other will come. Amendment, they call calling this particular document or calling a witness or something like that. But whatever the and other parts, so many objections are being taken. Try to consider all these things immediately then and there itself. And pass an order, doesn't matter. Pass an order, give a reason, one or two lines, three lines, four lines, whatever, give a reason, give it. And third, another most important is once the trial begins, not only after the trial begins, but even before that also, please try to maintain and keep up your docket more perfect. Everything get recorded. Let there be everything. No question of any short shabby writings, because there are many officers we have come across, not of late for last 10 years or so, at least I'm seeing officers having a good handwriting. But earlier, when you were 70s and 80s, I used to come across, in fact, the district judges having a shabby handwriting. In fact, two officers whom I know, I will not name them, they did not get promotion only because of the shabby rating after looking into the dockets and other things. So therefore, these are all things which you have to rather follow and see that ultimately you cater to the need of the justice. So the trial, you should not, because there are many things. In fact, I'm telling you, just as we at the high court level or appellate court level, the judges are more afraid of opening a bundle for the arguments, because once they look at the bundle, oh, what a big case. So therefore, it's like that. You also need not worry about, even if you look at the bundle or the type of the suit, the type of questions involved, you did not get shattered, or you don't get uh, unhampered, unhindered by all these aspects. Once you open, ultimately, I'm sharing with you that even the biggest of the biggest case will have only that circle within the circle, circle within the circle, circle within the circle. The shortest narrow aspect, only one point on which the entire case depends. Try to identify. Suppose I am really agree with that, because you did not pay me by that 10 rupees which I lent you. But I file a suit against you for 10,000 rupees. Suppose once you identify that Prakash Rao has given only 10 rupees, not 1,000 rupees, I will be very happy to receive the DPD for 10 rupees and walk away. I may not even file appeal against the 990 rupees also. So therefore, identifying that core question is a is an art. In fact, the moment you open a bundle, your eye should fall on that relevant aspect. The moment you you try to read it, you must be able to locate that particular gray area where the parties are at dispute and other things. So with these things, and in fact, I wish I am there before you face to face each other, and all aspects could be particularly be discussed in detail and shared. I hope all this COVID period will be over as early as possible, and will be back in action face to face in other things. So with this, I thank you, and I'm just concluding. And as I'm mentioning to you, if any questions are there, please most welcome. I'll be very happy to, because one thing is, remember, no doubt I'm just trying to keep in touch with the law and subjects and other things. I've been, because as a district faculty to 4 universities locally, and also participating here and there in our academic pursuit and this is also. But though there is a gap of more than 10 years now, be that as it may, the experience doesn't go anywhere. Once you have an experience, that is, even as a lawyer, as a judge, as a anything, as a law teacher or whatever it is the experience which counts. And another thing also, please, because everybody will be looking will be vying against us, we the judicial officers, because even our the law professors, academic side, they will not like a judicial officers coming and try to tell us, because we will be telling in a more practical angle than telling in the 1+1 2 and stop it. This is what bookish. We are not bookish. So therefore, tomorrow, all of you, I wish you all, each one of you, very good luck. And I hope tomorrow you will become maybe High Court judges, Supreme Court judges, and also land you far better places. Thank you. Thank you very much. Hello.
Friends, have you got any questions to be raised? You're requested to put your questions to my lord.
I hope I have covered the timing.
Yes, my lord. My lord, you explain the subject in lucid and comprehensive manner, and it is of enormous help to all of us. Despite your busy schedule, you are kind enough to accept the request of the Academy to address the young officers. Lord, the Academy is very much thankful to your lordship for sparing your valuable time and giving us guidance. Thank you very much, my lord.
Thank you. Thank you. Convey my regards to all.
Thank you, my lord. I will certainly convey.